we have with us an esteemed panelist, Mr. Keshan Talgahagoda. Mr. Talgahagoda is an attorney at law with over 25 years of experience, specializing in corporate and commercial law. A founding partner of Equitas Legal, he advises on mergers and acquisitions, e-commerce, company liquidation, restructuring, intellectual property, banking, insurance, and commercial agreements. He holds a Master of Laws from the University of Wales and is a SIMI accredited mediator. I warmly welcome Mr. Keshan Talgahagoda, attorney at law, for today's session. To moderate today's session, we have with us Mr. Akila Alutwate. Mr. Alutwate is an attorney at law with over 5 years of experience in civil and commercial law. He holds a Master of Laws in Commercial Law from University of Colombo. I also warmly welcome Mr. Akila Alutwate, attorney at law, for today's session. And without any further ado, I invite him to commence today's proceedings. Over to you.
Thank you, Sri. Thank you for your warm welcome. Good evening to you. Good evening to you, sir. Today we have as a resource person, Mr. Keshan Talgahagoda, sir. Thank you for accepting our invitation and getting on board with this session. I know that you are a very busy person. I think Mr. Talgahagoda need no further introduction. And I also would like to welcome our participants who have joined us today with this webinar, despite the severe weather condition that is prevailing in the country. We hope that you are safe, and we'll hope that you remain in your respective residences safely. And I would also like to thank the Webinar and Legal Symposium Committee for organizing this webinar and having us to conduct this webinar. And also, I would like to gently remind you that due to the severe weather conditions prevailing in the country, we might have to experience certain technical difficulties and interruptions. So bear with us. We will try to rectify as soon as possible in the event, any such event. Today's topic is Introduction to Intellectual Property Rights. I know that is a vast area of law. We have to try and squeeze it into a 1 hour session, and Mr. Talgahagoda has taken up that challenge. Then, without further ado, sir, I will invite you to proceed with your presentation. Over to you, sir.
Thank you very much, Akila, and thanks, Isuri, for the introduction. Good evening, everybody. I hope you are all keeping safe and are joining us despite the extremely bad weather that we are experiencing across the country. So the topic that I have selected to present to you today, in line with the general theme of basics of law, is an introduction to intellectual property law, intellectual property rights. Now, this, like Akila mentioned, this is a very, very big area that is impossible to cover over such a short period of time. But we are just going to touch only on the basics. It's just going to be an introductory session. I'm going to go on the basis that the people who are joining this session don't have much of a background in intellectual property law. So I will be starting off with the absolute basics. Now, first and foremost, we must understand what is meant by intellectual property. Now, intellectual property is a form of intangible property, but like any other kind of property, that is, whether it is movable property or immovable property, intellectual property, that is property or the creations of the mind, creations of the intellect, are also capable of being owned. So it has a monetary value to it. And because of this monetary value to it and the capacity or the capability of intellectual property being owned, it can also be transferred, sold, licensed, assigned, etc. And also, if the owner of the intellectual property is an individual, his death doesn't extinguish that intellectual property. So like any other kind of property, whether movable or immovable, it belongs part of the person's estate and will devolve on his intestate heirs or can be bequeathed by a last will. So just keep in mind the fact that intellectual property, although it is intangible, it has very much the attributes of any other type of property. Now, when we talk about intellectual property protection, we must keep in mind that intellectual property protection is territorial in nature. Now, what is meant by territorial in nature is that it is protected within a particular jurisdiction. So you take, for example, a trademark. Now, a trademark that is registered in Sri Lanka, by the mere fact that it is registered in Sri Lanka, won't assure it or won't guarantee it or won't provide that trademark registration in India or in Australia or in England or wherever. So if a person intends to carry out his business in any of those jurisdictions, he would be advised to register his trademark in those jurisdictions. So that is another aspect of intellectual property that must be kept in mind. That is that intellectual property protection is territorial in nature. Now, the types of intellectual property that are covered under our law, basically, we talk about patents, trademarks, copyrights, industrial designs, and geographical indications. Now, we will just, for the purposes of this presentation, we'll just talk about patents, trademarks, copyrights, and industrial designs. And we will also talk about the concept of unfair competition, which is an integral part of our Intellectual Property Act. Now, another question that may arise is how the law protects intellectual property. Right? So now what intellectual property protection does is that it provides the owner certain exclusive rights to monetize that intellectual property. The exact nature of those rights change from the kind of IP involved, but essentially that is what IP protection does. It gives exclusive rights to the holder of that IP. Now, what is the reason? What is the rationale for the law protecting intellectual property? So the law protects intellectual property because otherwise, in the absence of protection given to intellectual property, there is no incentive to create. So you take, for example, it's best illustrated with things like copyright and patents. Now, an inventor, if he doesn't have the assurance that his invention is going to be protected by law, that other people can't copy his invention, property protection encourages and incentivizes innovation and creativity. And that in turn fosters economic growth. Intellectual property also safeguards consumers because it provides authenticity and quality in respect of the products and services that are associated with that intellectual property. Now, intellectual property in Sri Lanka is governed by, I'm sure most of you would have heard about it, the Intellectual Property Act number 36 of 2003. Now, these are all-encompassing act that provides for protection of copyrights, industrial designs, patents, trademarks, trade names, as well as protects against unfair competition. The Act also provides for the process and the procedure by which intellectual property is registered. And importantly, it also provides extensive provisions with regard to the enforcement of the protection mechanisms. So in the event of a violation of intellectual property, how the law enforces the IP rights. Now, those are also enshrined in this particular statute. So it is an all-encompassing law. It's based on the TRIPS agreement, and it replaced the old intellectual property, the Code of Intellectual Property Act of 1979. It's much more comprehensive statute. And yes, so we can now just move on to the first aspect that we are going to talk about. And though this is not in order in which it is provided for in the Act, I want to start with trademarks and unfair competition, for the reason that I think that is an area in which lawyers will be called upon to advise clients the most. So let's start with the concept of trademarks. Now, what is a trademark? So essentially, a trademark literally means a mark that distinguishes a trade. Basically, a trademark serves to identify the goods or services as originating from a specific business and distinguishing it, differentiating it from those of its competitors. Now, trademarks can consist of text, words, logos, symbols, design elements, or even a composite of several of these elements. Right? So a word mark, that is just where you're registering only the word as a trademark, we call it a word mark. A device mark is a mark where the mark that is registered is either a logo or a symbol or something that has a design element to it. A composite mark is a mark that combines various elements such as words, text, graphics, logos, colors, etc. So if the question arises, if client comes and asks you, this is my name, this is my trading name, what is it that I should register? How should I register this mark? So one thing that must be kept in mind is that you can register a mark in different ways. So you take, for example, the mark Coca-Cola, right? So Coca-Cola will be registered as a word mark. That's a simple words Coca-Cola is registered as a trademark. That is without any of the stylized writing, the colors, etc. Without that, the simple text is registered as a word mark. In addition to that, the stylized writing of Coca-Cola that we are all familiar with is also registered as a trademark by itself. So trademarks can be registered in numerous ways. And obviously, if you want to protect your mark, you register it in as many ways, in as many iterations as possible. You register it as a word mark, you register it as a design, etc. Right? Now, the purpose of a trademark is, like I mentioned, it indicates, it helps a consumer identify goods or services as originating from a particular trader. So like, for example, I buy a chocolate, let's say it's the Revelo, Ritzbury's Revelo brand. Right? I like that chocolate. I go back to the supermarket and I look for that brand. I look for chocolates sold under that trademark because I have come to associate quality with that particular brand. So that is the purpose that a trademark serves in trade. Right? Now, if we move on, how do you register a trademark? Now, the trademark registration commences with an application that is submitted to the National Intellectual Property Office. Now, I won't go into this in too many details, but trademarks have to be registered in a particular class. That is, there are several international classes and goods or services belong to one of these classes. So the trademark, now, for example, if the trademark is in relation to tea, like Dilmah, right, you will register that particular trademark in the class to which tea belongs. It comes under beverages and so on. Right? So like that, you need to find out what class the particular business is associated with and register that mark in that particular class. Now, one of the key things that must be kept in mind when you try to register a mark, or when you want to register a mark on behalf of a client, is that the objective of the trademark is distinctiveness. So in the absence of distinctiveness, if that mark is incapable of distinguishing and identifying that business, we say it lacks distinctiveness. And a mark that lacks distinctiveness cannot be registered. Now, I'll just, so when an application is received by the National Intellectual Property Office, the IP office does two things. One, it checks the mark against what is called absolute grounds. Now, absolute grounds are basically to see whether the mark is purely descriptive or not. So purely descriptive marks cannot be registered. I'll give you an example. Now, for example, let's say somebody is doing a business of car rental, car hiring. So he names his business Colombo Car Rentals. Now he wants to register a trademark, Colombo Car Rentals. Now that particular trademark most likely is going to get rejected. The application is going to get rejected on the basis that it is purely descriptive. Colombo Car Rental describes the business that that person is doing. So you can't claim exclusivity for something like that, right? Similarly, a cleaning service that goes by the name of Sri Lanka Cleaners, right? Again, descriptive. So you won't be able to register it. Similarly, trademarks that use common surnames or geographical locations cannot be registered as trademarks, right? So if your name is Fernando and you want to register your business as Fernando Enterprises or something like that, you can register your business as Fernando Enterprises, but you can't register a trademark with the name Fernando because it is a common surname. So those are called absolute grounds. So the trademark office will first see whether the mark is prima facie distinctive and that it is not descriptive. If so, it will go on to the next ground, that is the relative grounds. That is, the trademark office will basically check the application, check the trademark to see whether it is similar to existing trademarks, either in the register or well-known international trademarks. So essentially, in the second step, what the National Intellectual Property Office is doing is to see whether the mark that is sought to be registered violates any third-party rights. Now, so the first thing that they do is they look through the register to see whether there are similar marks, confusingly similar marks. And the mark doesn't have to be identical. If the mark is similar to an existing mark, the application will be rejected. Similarly, even if the mark is not registered, if it is a well-known mark, the application will be registered. So for example, you take a well-known international mark, which is not registered in Sri Lanka. Somebody tries to register that mark in Sri Lanka, the IP office will likely, in all likelihood, reject that application, even if that international mark is not registered in Sri Lanka. So those are the absolute and the relative grounds on which a trademark application can be rejected. But assuming that it satisfies both those criteria and the IP office accepts it for registration, the next step is publication. The mark is published in the Gazette. And once it is published in the Gazette, any third party, any person has the opportunity to object to the registration. So for example, even if the application has slipped through the investigative process of the IP office, if the mark that is published is similar to a third party's trademark or violates a third party's rights, that third party has every opportunity to file what is called a notice of opposition to the registration of the trademark, and thereafter the trademark office will inquire into that objection and then decide whether or not to register the trademark. Now, if a trademark is registered, once a trademark is registered, what does that confer upon the owner of that trademark? So basically, the owner of a trademark has the exclusive right to use that trademark for his goods or services. So corresponding to that right is the ability or the right to prevent a third-party competitor from using his trademark without his permission or using a confusingly similar trademark. So trademark infringement doesn't necessarily arise only if the infringing trademark is an identical replica of the registered trademark. It is sufficient if the infringing trademark is confusingly similar to the registered trademark. And if that is the case, then there are provisions in the IP Act for enforcement against that act of infringement, which we will just touch on at the end of this presentation. Now, a trademark registration is valid for 10 years, dating from the date of the application. Now, this is something to keep in mind because the trademark application process itself takes a few years. So, for example, if you applied for a trademark in 2023, the mark might actually be registered only in 2025 because that whole process needs to take place. But once the registration is granted, it is backdated to the date of the application. So the 10-year period, the initial 10-year period commences from the date of the application. And thereafter, the trademark can be renewed on the payment of a renewal fee for consecutive periods of 10 years indefinitely. So a trademark can be on the register for an indefinite amount of time, so long as steps are taken to renew the registration every 10 years. Now, this must be contrasted. You can contrast this with the other types of intellectual property like copyrights, patents, and industrial designs, where the exclusive rights that are conferred, registration or the exclusivity of the mark is limited in duration of time. Trademark, so long as the mark is renewed, can be kept in force indefinitely. We'll move from trademarks now to unfair competition. The reason I'm dealing with unfair competition along with trademarks is because in infringement actions, very often unfair competition is linked with trademark infringement. Now, unfair competition is basically a statutory recognition of the English tort of passing off. Right? The English tort of passing off, the tort of passing off under English law receives statutory recognition under a IP Act, but the Act significantly expands the concept of intellectual property, expands the concept of unfair competition. Now, what is unfair competition? Unfair competition essentially is, it literally means competition that is not fair, right? And the IP Act seeks to protect businesses and consumers from unfair and dishonest commercial practices. Now, protection against unfair competition exists even in the absence of a registered trademark, copyright, registered invention, patent, etc. Right? Because the provisions relating to unfair competition operate independently of the other provisions of the Act relating to copyrights, designs, patents, and trademarks. Right? Now, by that itself, it can be seen that unfair competition is a very, very wide area. Right? It encompasses a lot of wrongdoings in business and commercial activities. And very often in infringement cases, we use unfair competition as an alternative cause of action as well. So even in the absence of an infringement action or an infringement cause of action, you can found action under unfair competition. Now, very often we use unfair competition as a cause of action when you don't have a registered trademark. So if you have an unregistered mark, a trading name that you have developed and you have goodwill in that name, even in the absence of registration, through the concept of unfair competition, you can prevent competitors from unfairly using that name. Now, the provisions relating to unfair competition are found in Chapter 32 of the IP Act, that is Section 160 onwards. And there are several categories of activity that the provisions relating to unfair competition seek to prevent. One is deceptive trade practices. That is where somebody tries to confuse or mislead the consumer by projecting his business as originating from somebody else's. So that is similar to a trademark infringement. Basically, you either use a similar packaging, you use similar color schemes, you use identical promotional material, etc., basically to confuse the consumers. The second type of unfair competition dealt with under the Act is practices that damage goodwill. Now, goodwill is the value that your business has obtained through your efforts of advertising, promotion, and sales. Now, any act that dilutes goodwill is an act that damages that goodwill. And therefore, that can be also restrained under the provisions relating to unfair competition. Another category is misleading practices. Now, misleading practices, when we talk of misleading practices, what we mean here is misleading advertisements, for example. One category of misleading practices is misleading advertisements. So, for example, where the advertisements mislead the consumer with regard to, say, discount schemes or warranty schemes, the features of a product, the attributes of a service. If the information that is sought to be conveyed to the consumer is wrong, is false, is misleading, that particular act can be prevented under the IP Act relating to unfair competition. Another aspect is to prevent acts that are disparaging of competitors. So you can, the IP Act and the law encourages fair competition. It encourages fair competition. So you can compete. Obviously, you need to compete. In a capitalist society, you need to compete. But you must compete fairly, which means that you can't disparage your competitor. You can't accuse your competitor of selling substandard products, or that his products are going to harm the consumers, etc. That is something that the law won't permit. Now, one other aspect of unfair competition that is very important to keep in mind, which is slightly different from the matters that I just mentioned, is the protection given to undisclosed information. Now, you have, most of you would have heard of NDAs, non-disclosure agreements. That is where two parties enter into an agreement whereby either both parties or one of the parties agrees not to disclose confidential information that is received by that party. Now, the IP Act introduces in section 160, subsection 6, provisions preventing the unlawful disclosure of undisclosed information. So what this essentially means is that even in the absence of an NDA, traders have the right to protect their undisclosed information. So even if there is no NDA, you can go to court and seek an injunction preventing the disclosure of your confidential or secret information. So that is something to keep in mind, that is provided for under the Intellectual Property Act. We'll move now to another aspect of intellectual property, and that is copyrights. Now, again, the reason I'm dealing with this here is because this is another area where young lawyers may have clients seeking advice on. So because you have a lot of authors, songwriters who don't have, there is a tremendous lack of knowledge and awareness on copyrights and the protection offered to creative works. Now, the scope of copyright protection, what does copyright protect? Copyright protects original intellectual creations. This is the definition from the Act itself. Copyright protects original intellectual creations in the literary, artistic, or scientific domain. So under this very wide definition, you basically can cover so many different things. So books, articles, speeches, all constitute literary works. Artistic works would be musical compositions, songs, artworks, sculptures, dramatic works, films and TV shows, sound recordings, photographs, etc. Scientific works would include software programs, architectural drawings, maps, and so on. Basically, anything that is original and an intellectual creation is entitled to copyright protection. Also protected are what is called derivative works. A derivative work is a work that is based on an existing copyright protected work. So, for example, if a novel, a novel that is in English is translated into Sinhalese, there is a copyright protection that extends to that singular translation. So that translation is considered to be a derivative work, and that itself has copyright protection. Similarly, when a book is converted into a movie, the screenplay is considered a derivative work, and that itself has copyright protection. Now, there are a few key attributes of copyright that must be kept in mind, right? The primary or the fundamental attribute necessary to secure copyright protection is that the work must be original. The work must be original. Copyright protects only original works. Now, there is a distinction here between originality that is expressed and original ideas. Copyright does not protect ideas. Copyright protects only the expression of that idea. So the idea need not be original. All that needs to be original is the expression of that idea, and it must be independently created. So, for example, if I go and take a photograph of, say, Sigiriya from a particular angle, my friend uses his camera to take a photograph of Sigiriya from the same angle under the same lighting conditions. Now, both of us have the same idea, but that doesn't mean that my friend's photograph infringes the copyright in my photograph, because both of those photographs constitute independent expressions of that idea. So this is something that must be kept in mind. A lot of people don't understand or appreciate this distinction between ideas and the expression of the idea. As very often happens, you have, for example, a book that becomes tremendously successful, and then somebody comes out of the woodwork and say, hey, look, this plot is my idea. I came up with this idea. I came up with this plot. But no, but that is not what the copyright protects. Copyright doesn't protect that idea. Copyright only protects the expression of that idea. Right? Another thing that needs to be kept in mind when it comes to copyright is that unlike other aspects of intellectual property like trademarks, patents, and industrial designs, copyright, in Sri Lanka at least, there is no provision to register copyright. There is no provision to register copyright. So copyright exists. Now a trademark is considered registered once the application is accepted and the trademark is entered in the register at the IP office. Copyright comes into existence by the creation of the work itself. So the moment you put something to paper, the moment you express your idea, so long as it satisfies the requirement of originality, copyright is created. Copyright comes into existence. So obviously inherent in this is there is always going to be this difficulty in proving that the copyright belongs to you. So this is something, again, that you must keep in mind if people come and seek advice from you. How do I protect my copyright? How I have written a song, I have written a book, I have written a screenplay. How do I protect my copyright in this work? The only way you can protect your copyright is to clearly identify that work with yourself, which means that you have to ensure that your name is clearly displayed as the creator or the author of that particular work. So especially this you need to keep this in mind, especially or authors need to keep this in mind, especially when they are making available their demos and their scripts, their drafts. to publishers or to broadcasters or to producers, ensure that there is a paper trail which identifies that work with you. Otherwise, there's nothing to prevent you. You send a script to a publisher, the publisher will write and tell you, no, there's nothing, we can't publish this. They'll take your script, change the words a bit and publish it under somebody else's name. So the only way to protect yourself against that is to ensure that there is a paper trail and to ensure that your name is prominently and clearly identified as the author of that particular work. It's not always easy to do, but it's something that has to be done. So, for example, in photographs, if you're going to put your photographs, if you think your photographs are good enough and you want to publish it on social media or whatever it is, ensure that you put a watermark. Right? Ensure that you put a watermark on that photograph, identifying yourself as the creator of that photograph, and tell your clients to do likewise. Right? One thing I missed earlier when I talked about the attributes of copyright is that copyright is not concerned with quality or purpose. And what this means is essentially even the ugliest painting, even the worst song, even the most ridiculous novel is entitled to copyright protection. Copyright protection is not dependent on the quality of the work. The only criteria, only requirement is that it has to be original. Right? Now, what does copyright protection offer the creator? The exclusive rights that are given to the author of a copyright protected work. So essentially, the author or the creator of a copyright protected work has the exclusive right to reproduce, distribute, perform, adapt their creative works. So if you write a novel, right, you have the exclusive rights to publish that novel, to reproduce that novel, to authorize somebody else to translate that novel, to authorize somebody to adapt the novel for a screenplay. These are essentially called economic rights associated with copyright. Now, the key thing about economic rights, and it's actually one of the necessary attributes of copyright, is that economic rights can be sold. They can be licensed. So you write a book, obviously you don't have the infrastructure to publish that book yourself. So you need a publishing house to get involved. So you will sell the rights to that book to a publishing house who will do the publishing on your behalf. Right? So those are the economic rights, essentially the right to publish your work, the right to perform your work, the right to record your work. If it's a song or a movie or whatever, it is the right to record your work, the right to broadcast your work. Right? Now, corresponding with economic rights, you have something called moral rights. Now, moral right essentially is the right to be identified as the author of that work. So even if you have sold your economic rights, so even if you have sold this novel you wrote to a publishing house, you have the right to ensure that when that book is published, you are identified as the author. So even once you have transferred or sold your economic rights, your moral rights remain. So moral rights essentially primarily are to be identified as the author of the work, and secondly, to object to the distortion of the work. So nobody can take your work and then basically distort it. Take a song and completely change the melody, change the lyrics, etc. That itself is an adaptation which needs your permission. So moral rights subsist with the author, as even in cases where the economic rights have been transferred. So just keep that in mind, moral rights and economic rights when it comes to copyright, right? Another thing to keep in mind is that if a work is done, that is an artistic work is created while employed by somebody else, right? Then depending on the understanding between the employee and the employer, the copyright in that particular work may belong to the employer. So if that work is created as part of, in the course of your employment, within the scope of your employment, the copyright protection may accrue to the employer, not to the employee. Right? Now, how long does a copyright exist? Now, unlike a trademark, which I mentioned earlier can be renewed indefinitely, there is a limited period for which a copyright remains in force. And under Sri Lankan law, that is the author's lifetime plus 70 years. The author's lifetime plus 70 years, right? If it is a work of co-authorship, that is if 2 or more people have collaborated to create the work, it is the last surviving author's life plus 70 years. Now, at the end of, or the expiry of 70 years, we say that the particular copyright protected work enters the public domain. It enters the public domain. And now this is the reason why the works of Shakespeare or Charles Dickens, Alexander Dumas, etc., no longer have copyright protection. They are free. They are in the public domain and can be adapted and used as anybody wishes. Right? So copyright protection exists only for a limited period of time, and that is 70 years after the death of the author. To copyrights as well, and that is with regard to the use of copyright protected works in education and for purposes of criticism. We call this fair use. It's a bit of a complicated area that we just need to keep that in mind, that is something that people use as a defense sometimes when copyright infringement is alleged. Right? So unlike trademark infringement, where proving the trademark belongs to you is easy, one difficulty when it comes to copyright infringement is that you need to prove that you created the work, and this is not always easy to do. Another thing that you need to keep in mind is that in certain kinds of work, like audiovisual works especially, there can be multiple copyrights and multiple copyright owners. So you take a movie, for example, there will be one person who wrote the screenplay. So there will be a copyright in the screenplay. The producer will have a copyright in the movie itself. A composer will have the copyright in the theme, the musical theme of the movie. Right? If there is a song in the movie, the songwriter will have a copyright. So certain works, especially audiovisual works, can have multiple copyrights and multiple copyright owners. Same goes for a simple song, right? Very often in the entertainment industry, a song, the lyrics are written by one person, the music is composed by somebody else, the arrangement is done by somebody else, and the song is performed by somebody else. So there are different rights that accrue depending on who owns that particular right. Right? Okay. In addition to that, there are things called related rights. That is, for example, broadcasters' rights as well as performers' rights. So, for example, a performer has a right in respect of his performance. He has a right to basically prevent people from unlawfully recording his performance. Right? That's another area that is covered by the IP Act with relation to copyright. Right? Since we are very short on time, we will move quickly on to patents and industrial designs. Right? Now, patents, to start with patents are basically inventions, right? The definition of an invention in terms of the IP Act is that an invention is an idea of an inventor which permits in practice the solution to a specific problem in the field of technology. An invention is the idea of an inventor which permits in practice the solution to a specific problem in the field of technology. Right? Now, in order for an invention to be patentable, 3 criteria have to be satisfied. One is novelty. That means the invention must be new. So in legal terms, you say that the invention must not be something that is anticipated by the prior art. Now, that's a legal term, but essentially what it means is there must not be anything of this nature that has been published anywhere else in the world. So when you seek to register a trademark, the Trademark Office carries out an extensive search, not only of the trademark registers in Sri Lanka, but international trademark registers as well, to see whether this invention is actually novel. The second aspect that needs to be satisfied is that the invention must involve what is called an inventive step. Right? Again, what this means is that what is sought to be registered as a patent must not be something that is obvious. It must be something that is not obvious. So if there is a hole through which oil is leaking, closing that hole is something that is obvious to somebody who has ordinary skill in that art. So the mere fact that you design a small door to cover that hole won't give you a right to a patent. Right? And the third criteria is that your invention must be industrially applicable. It must be capable of being used in industry. Right? Now, patents, though the term patents generally signify a patent in relation to, say, a machine or a piece of equipment, it's not just limited to that. You have process patents. That means a certain industrial process can be patented. Patents are granted in respect of formulas, especially when it comes to medicines, drugs. Right? The formula for a particular drug can be patented. Right? New technologies can be patented. That is why, for example, you say Apple or Samsung, they have hundreds and hundreds of different patents. Every little innovation, they go and patent it. Right? Now, what is it that a registered patent allows the patentee to do? So first of all, again, like copyright, patents are limited in duration. A patent expires 20 years after the date of filing. 20 years, only 20 years. And there is no provision for renewal of a patent. Now, why is this? Why does the law give only a limited period of protection to a patent? Because, see, what the patent does is it gives the exclusive rights to the patentee to exploit this patent. The patentee has the exclusive right to monetize his patent, to license his patent. But when you concentrate the exclusive rights in one person for an indefinite period of time, it's going to stifle innovation. The law has to encourage the development of technology. So that is why the law gives the patentee the benefit of 20 years to monetize and exploit his patent. But at the end of the expiry of the 20 years, like in copyrights, it enters the public domain, and anybody thereafter can make use of that patent, improve on it, use it, etc. Right? And like other aspects of intellectual property, patents, you can prevent the unauthorized use or exploitation of a patent through the provisions, enforcement mechanisms provided under the statute. The final aspect of IP that we are going to deal with in this particular presentation is industrial designs. Now, industrial designs basically protect the design of a product. Now, a patent protects the technology, it protects the invention. A registered industrial design is only concerned with the aesthetic design of the product. So, for example, if you take a tile, the pattern of the tile can be registered as an industrial design. Right? If you design a shoe, the design of that shoe, the aesthetic design of that shoe can be registered as an industrial design. So it is only the aesthetics that are taken into consideration when an industrial design is sought to be registered. And the design must not be something that is dictated by functionality. If the design is in that particular way because of the functions, it won't be registered. So industrial designs can be registered and they're protected. Novel industrial designs can be protected for the initial period of protection is 5 years, and thereafter it is renewable for 2 further periods of 5 years, meaning that you have a maximum of 15 years of protection that is given to a registered industrial design. Right? I hope I'm not going too fast, but then this is just a very, very basic introduction to the law, and the provisions in the statute itself are not very difficult to understand. So I would encourage anybody who is interested in this to just familiarize yourself with the sections in the statute, because once you get a grasp of intellectual property rights and intellectual property law, it's not a very difficult area, and it's a very, very interesting area as well, right? And especially in the modern context, today's context, where we are dealing with new technologies like AI, right? Intellectual property has taken on a completely different dimension with regard to, especially with regard to copyrights, and copyrights interplay with generative AI, that is large language models like ChatGPT. Right? So let's talk briefly about the remedies and enforcement rights of IP, right? You have civil remedies, and then there are criminal consequences as well. So the civil remedies, when it comes to IP infringement, the obvious remedy that we all employ is to go into court and get an injunction restraining the continuing infringement of IP rights. So if there is a threat of your copyright being infringed, your trademark being infringed, you can go into the Commercial High Court. Remember, it is the Commercial High Court that has exclusive jurisdiction in respect of matters under the IP Act. You can go into court and get an injunction to prevent infringement. In addition to an injunction, you can obtain compensation, damages. So the fact that an injunction is available won't disentitle you from damages, unlike the normal common law, which says that where damages is an adequate remedy, an injunction won't lie. That is specifically excluded when it comes to IP. So in addition to getting an injunction, you can get compensation. There's also something called statutory damages. That is, even without having to prove actual damage, the statute provides for a particular sum to be paid as liquidated damages. There is another limb of damages you can claim, and that is the accounting of profits. So for example, if somebody has infringed your trademark and traded under that trademark for, say, 6 months or 1 year, you can get the court to order that person to account for all the profits he made during that period by infringing your trademark, and for an order for those profits to be paid to you, right? In addition to the civil remedies, right, there are also administrative and border measures that are in place to prevent the entry into the country of counterfeit goods. And there are also criminal consequences for violation of IP. So especially when it comes to counterfeit goods, there is a criminal element to it as well. So you can be fined, you can be imprisoned for certain types of IP violations, right? So I think that is probably a very, very brief overview of intellectual property law as it is identified or as it is practiced and applied in Sri Lanka. Obviously, you have to go in. I mean, if you're interested in this subject, you need to go into it in a lot more depth. It's much more complicated when you actually start practicing it. But it's a very, very interesting area as well. And it's an area where not many people are versed in. You see lawyers practicing, doing intellectual property cases without having the knowledge about the Intellectual Property Act or the concepts of intellectual property. So this is something I think that should be remedied. It's not a difficult area of the law if you're interested in it. So with that, I'll hand this back to Akila. Do we have any questions, Akila, from?
Yes, thank you very much. So that was a very insightful session, very insightful presentation, sir. I have a question of my own to present to you, sir. What exactly is the difference between a brand name and a trade name? How do you distinguish between the two, and what sort of rights those two trademarks or brand name or trademark would attract in terms of law?
Yeah, so that's a good question, Akila. So essentially, again, this is something that people don't, I mean, you trade under a particular name, you have a particular brand. So you can register both a trademark and a trade name as well as a brand name as a trademark. So when you talk about brand name, that really doesn't have a legal meaning. Right? The word brand name is not used anywhere in the act. So a brand name will be protected if it is registered as a trademark. Right? Trade names generally are now, for example, you take a sole proprietorship or a partnership, they will have their trading name. That is a trade name. Right? Now you can go to the extent of registering your trade name, but even in the absence of registering your trade name as a trademark, the law protects trade names. So the law will protect somebody from using a trade name that is similar to your registered trade name. So there is essentially whether it can be registered as a trademark or not depends on whether it satisfies the criteria of distinctiveness and it doesn't infringe somebody else's rights. But even if you have not registered it as a trademark, the law will still offer some kind of protection.
Thank you very much, sir. And from our audience, we have several questions. Now there's a question, sir, which is in regard to whether she's asking whether it is advantageous to mention the copyright. Now there's a copyright notice, sir, with C without a circle. There's a person from the audience is asking whether to give notice in a certain copyrighted work is particularly advantageous rather than mentioning the identity of the creator or mentioning the identity of the creator is alone enough, or whether you should give notice as well.
So ideally you would put a full copyright notice that, for example, what you see in a book, you would put that full copyright notice. But the very least, when I said identify yourself as the author, that is the bare minimum. The bare minimum is to say that I wrote this, essentially. Right? But obviously, it's better if you can put a comprehensive copyright notice.
Copyright mark. Right, sir. Then we have another question from the audience, sir. They're asking, sir, what sort of book that you would recommend to understand the practices and procedures and the substantive law in relation to intellectual property law in relation to the legal regime in Sri Lanka?
So in Sri Lanka, there aren't a lot of sort of textbooks that deal with IP law in Sri Lanka that can be really recommended. But intellectual property law, one advantage of intellectual property law is that the law is the same whether it is applied in Sri Lanka or England or India. Essentially, the concepts don't change. So
it's a common law, right?
So you can, there are Bentley and Sherman on intellectual property is a very good book. Cornish on intellectual property is a very good book. Atia is not Atia. There are some other Indian books as well, which are very good. So there are so many different books on intellectual property that you can read. Dr. Cabral has a book on intellectual property, which you can read with reference to the Sri Lankan aspect of it. But there aren't a lot of books that deal specifically with the law as it is applied in Sri Lanka. But you don't need to do that, because the law that we apply here is what is applied in England or India, Australia, or the US.
So basically, the common law, it is what applies to us as well. Sir.
That is because it's a relatively new area. It's the law is common, and IP is governed by international conventions, the TRIPS agreement, and so on. So because of that, there is an international dimension to IP, and therefore, basically reading. And I would suggest that if you really want to understand IP law, read the new judgments. Read the new judgments, whether it is of the Supreme Court in Sri Lanka or England, and especially the US, where you get all these high-profile IP cases being argued, because because they will deal with all the new material.
That's correct, sir. So with that, sir, that's all the questions that has been posed to us. So we'll move to conclude this session. So I will hand it over to Isuri for you to conclude this session. Thank you very much, sir. It's been really insightful. Thank you very much once again. for your insight.
Thank you very much, Akhil.
Thank you. This brings us to the end of the 22nd webinar of the series on Basics of Law titled Introduction to Intellectual Property Rights. I thank our esteemed panelist, Mr. Keshant Talgahagoda, Attorney at Law, and our moderator, Mr. Akula Alutwate, Attorney at Law, for the fruitful and educational discussion and for dedicating your time to be here with us and sharing your insights. I thank the BSL Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this webinar. I also extend my thanks to all the participants who have joined in for this session today, especially amidst the existing weather conditions. As I have said in the beginning, we will continue to strive to hold these webinars in spite of the difficulties for the benefit of the membership. So thank you once again, and I hope you all